Good evening, everyone. Welcome to this webinar on the topic of the differential treatment of publicity in healthcare and property and affairs cases in the Court of Protection. And we ask, not just rhetorically, is it justified distinction? We're extremely fortunate to have three very interesting speakers this evening. First speaker is Arianna Kelly, junior barrister at 39 Essex Chambers, and the directories record her to have an incredible eye for detail, and apparently her passion for the law is evident. Hopefully that will come through in her talk. No pressure, Arianna. Then we have Katharine Scott, also a junior barrister at 39 Essex Chambers. She is very experienced in the Court of Protection and has a sharp and incisive legal brain. No less sharp or incisive is Joshua Rozenberg, KC On, who is, he tells us, Britain's most experienced legal commentator, and he trains as a lawyer before becoming a legal journalist, which is always an advantage, and is known for his independence, authority, and his ability to explain complicated legal issues with simplicity, clarity, and wit. So perhaps he can explain to us what's going on in this area of law a bit later. Anyway, without further ado, I'd like to hand over to Arianna Kelly to start. Arianna.
Thank you so much. I will be speaking today around privacy and property and affairs applications. I'm just going to make sure my slides are up. And my sincere apologies. Hopefully that's with you. What I'll be talking about is privacy and property and affairs applications. I will just note at the outset that committal proceedings have their own rules and transparency requirements. And so this is talking about non-committal private property and affairs applications. I'll start off with a bit of an overview about property and affairs applications in the Court of Protection. Property and affairs applications are the vast majority of the cases which are heard before the Court of Protection. I've set out the 2023 family court statistics, which are the most recent ones available for a full year. There were 35,000 applications made to the Court of Protection in 2023, of which 22,418 were purely property and affairs applications. There were another 3,600 applications which related to lasting powers of attorneys or applications by existing deputies or attorneys, many of which will have also related to property and affairs. By contrast, the welfare jurisdiction is much smaller. There were 6,210 applications relating to deprivations of liberty and about 1,300 other welfare applications heard within the Court of Protection. So overall, really much of the work and the day-to-day work of the Court of Protection is around the management of people's property and affairs. Another really important thing to know about property and affairs is that the vast majority of property and affairs applications are not heard at attended hearings. Most of these applications are non-contentious, meaning that there is no one who's actually objecting to the application which is before the court. For these non-contentious applications, they're mostly heard without the person who the case is about being joined as a party. They're usually considered on the papers and no hearing ever takes place. There are a lot of reasons for this, but a really central one is that the cost of property and affairs applications are normally borne by the person themselves. So if there is legal representation within that case, it's coming out of the person's estate. Consideration on the papers without an attended hearing, and often without P being represented by a litigation friend in the hearing, saves P quite a bit of money because you're not incurring all the legal fees that would be involved in lawyers pitching up at a hearing and addressing the court. So some really common examples of these sorts of non-contentious applications would be an application for appointment as a deputy, property and affairs deputy, where the person has lost capacity to make a lasting power of attorney. This is incredibly common, and thousands of these applications are made every year for people who have lost capacity but still need someone to manage their property for them. Applications by deputies to buy or sell property for the person are also, again, really common applications in the Court of Protection because that's not part of the standard deputyship order in most cases unless authority is specifically sought by the court. So for those sorts of applications, there will never be a hearing and the person will not be represented by a litigation friend. This would really never come into the public domain. Welfare applications are often very different. As I've set out in the statistics, they're very frequently relating to deprivations of liberty of the person. In deprivation of liberty applications, unless it's an uncontentious one that the person isn't objecting to, P is usually joined as a party because that's important under Article 5(4) rights to make sure that the person does have an opportunity to have any objection to a deprivation of liberty tested before the court. It's also much more common for welfare applications to be considered at contested hearings, but again, that's not always the case. And if the deprivation of liberty is non-contentious, that may also happen without an attended hearing ever taking place. So, in looking at the subset of property and affairs hearings where an attended hearing actually does happen, the court does have broad case management powers to determine if a hearing is required at all. And that's always open to any judge who's considering a property and affairs application. One of the ways the court will consider whether or not an attended hearing is required is around the notification of the application. The person who the application is about, and normally at least 3 people who are interested in the person's welfare, have to be notified of any new property and affairs applications. There are also specific rules which relate to certain kinds of applications. In statutory wills, there are specific notification requirements which relate to making sure that anyone who's going to be affected by the new will has had an opportunity to be aware of the fact that an application is being made and to register any objection they might want to have. If there are objections, it's much more common for the application to be listed for a hearing to determine the matter, particularly if they seem like they might be a bit intractable. The court may also determine that the person needs representation, even if it's not a contentious application, but this is less common. In those sorts of cases, the person may need to instruct the official solicitor or some other litigation friend to act on their behalf, which again does incur quite a bit of cost for the person. And if it's not contentious, the court may simply choose to gather some further information rather than list it for an attended hearing. But it is always open to the court to decide that it does need lawyers to come in, address the court, and consider the issues in the case. So in considering the general rules around transparency in property and affairs hearings, there's a bit of a funny situation in which there are certain rules set out in the Court of Protection rules, but then practice directions which effectively set those aside in the vast majority of cases. The general rule in Court of Protection hearings is that hearings are to be held in private, and only the parties, even if they're not a party, legal representatives, litigation friends, and Rule 1.2 representatives and court officers may attend. But it's always open to the court to, even in a private hearing, authorize the attendance or exclude other people or classes of people from those hearings. The court can also decide, even in a private hearing, to authorize communication of information about private proceedings, or the court has the power to order a public hearing, which may include restrictions on publication about what has happened within that hearing. Since January 2016, even though the normal rule under Rule 4.1 of the Court of Protection rules is that hearings take place in private, is that attended Court of Protection hearings are in public, subject to reporting restrictions. This is all set out within Practice Direction 4C, which is on transparency, which states that the court will ordinarily, and so without any application being made, make an order that any attended hearing shall be in public and impose restrictions in relation to the publication of information about the proceedings. There is a standard reporting restrictions order, but this always does have to be made specifically in every case and should be tailored to the facts of any case. And that's something we'll talk about a little bit more later about the scope of that and whether these should just be made automatically or whether they should be considered on a case-by-case basis. But regardless of the outcome of those sorts of decisions, there is such a thing as a standard reporting restrictions order. And normally what it does do is injunct the parties, representatives, and witnesses, anyone who attended any part of the hearing, or anyone who obtains an account or recording of the attended hearing from disclosing certain information. A lot of that is closely focused on identifying information about who the person in the case is. And that usually extends out to who the person's family is due to the risk of jigsaw identification. Witnesses are often also covered by the standard reporting restrictions, though that is something that's been subject to more controversy and consideration in other cases, and that may fall out depending on how the Bossy decision goes. And that's something Katie will be speaking to you about in her talk. The court can also restrict other information as is seen necessary, and this may often relate to things like the person's address, medical information or treatment that they may be receiving, or other identifying information about the person. It usually does not restrict the publication of which public bodies are involved in the case, but this may occur if it would lead to identification of the person. This may also particularly be the case in places like small bespoke hospitals that only care for a really small patient population, and P may be easily identifiable if that hospital is named. Practice around property and affairs hearings, and in particular in attended hearings, also governs when hearings are to be attended and in public with reporting restrictions or in private. There's a definition of attended hearings in Practice Direction 4C, and attended hearings are defined as a hearing where one or more of the parties to the proceedings have been invited to attend the court for a determination of the application. So in general, that's most hearings. However, for property and affairs cases, there's a different sort of pathway that occurs, which means that not all of these hearings are often in public. Most of the hearings in property and affairs hearings are unattended hearings. This is a judge considering the matter on the paper without lawyers coming in to address them. This is also where the initial consideration of case management takes place, even if there's a view to eventually listing this matter for attended hearing. The first hearing in most property and affairs applications, which actually have lawyers and people coming into court, is called a dispute resolution hearing. A dispute resolution hearing is a sort of odd hybrid mediation hearing which takes place where a judge who won't ultimately determine the case looks at the issues in the case and tries to give the parties some indication of where they think matters are likely to land to help the parties consider any possible settlement. The dispute resolution hearing is essentially off the record in that way. So this is a hearing that's also not open to the public. The next hearing in the case management pathway for property and affairs hearings is typically known as the final hearing. So the final hearing of a property and affairs matter may be the first attended hearing which actually takes place. So really there's a huge amount of work which is actually being done around property and affairs application without ever having an attended hearing for the purposes of Practice Direction 4C. So this brings us on to the case which had prompted us to have this webinar today, which was the case of W&P, which is a really interesting case by Mr. Justice Raja. We don't know very much about the case because of the way that it was reported. There is no judgment on the substantive matters of the case. So what we have is really what we know about the case, and the underlying facts of the case comes out from the judgment which was given around the court's decision not to hold the hearing in public. What we do know about the case substantively was that this was an application for a statutory will. For anyone who may not be familiar with this, this is where the Court of Protection can make a will on behalf of the person where they find that it's in their best interest to do so. This is sometimes done around estate planning or where a person may have an estate which is likely to be highly contested after they pass away. And there may be a view taken, and often a compromise view, between the people who might potentially inherit from different wills to settle that during the person's lifetime to avoid a fight after death. There may also be cases where a person's situation has moved on quite dramatically, and it's appropriate for measures to be taken to reflect what had happened in that person's life, even if they hadn't gotten around to taking the will themselves. There's a wide variety of reasons why statutory wills can be brought, but tax planning is often a very common reason for it. In this case, what's set out from the judgment is that the purpose of the statutory will seemed to be very much estate planning, where P was an elderly person and had a limited life expectancy. It did not appear that the application was opposed, but it was set down for an attended hearing, so we don't know the full reasons why the court had decided to do that or considered that it was appropriate in that case. The person in the case was an unnamed individual and are described as having formerly been a public figure and having significant private assets. The judgment also sets out that the person in the case now had severe dementia and was unable to communicate. Again, the statutory will application in this case did seem to be one which, from the face of the judgment, did not seem to be attracting a lot of controversy. The only named parties in the application, as was set out, were W, who was the wife of P, and P himself, who was represented by the official solicitor. It didn't appear that other family members were joined, but again, we know very little about the case, and this is only what appears to be the case from what we have, rather than anything that we know definitively. So the matter was set down for an attended hearing, but the wife in the matter made an application that the court not make the normal order that the hearing be in public with reporting restrictions without hearing the wife on this point first. The court held an initial private hearing to consider the application without notice to the media, and Mr. Justice Raja determined to also hold the substantive hearing in private and without notice to the media. No judgment on the substantive issue was reported, and no reporting restrictions were made because the hearing was in private, and where the hearing is in private, there's no requirement for any reporting restrictions order to be made because no one is allowed to attend except the parties, P, the legal representatives, and court staff. The court set out some of the reasons why it decided to proceed in this way. It stated that the public interest lies in knowing what goes on in court. It is primarily about ensuring public scrutiny and accountability of court process and decision-making. There may be features of a particular case which enhance or raise the public interest in transparency. There is, however, a clear distinction between the public interest and what the public is interested in. The public may be curious about the private affairs and the wills of those in the public eye. It does not follow that there is legitimate public interest in those matters. The fact that the family may be in the public eye does not mean that their right to respect for private and family life in relation to matters which are not in public domain deserves any less respect than anyone else. And the court continued on that in this case, a public hearing which identified P would inevitably result in insignificant publicity to satisfy public curiosity. That would be a serious intrusion in the private life of P and his family. For reasons on which I will not elaborate here, this could have serious consequences for P and his family. The supposition that a transparency order would protect P's privacy is in this case displaced. It is not possible to craft reporting or other restrictions which would protect P's identity and the privacy of P and his family. There is a very significant risk of jigsaw identification unless the reporting restrictions and other measures such as exclusion of part of the public from parts of the hearing were so stringent as to make a public hearing meaningless. This substantially outweighs any legitimate public interest in its hearing being in public, even with reporting restrictions, and amounts to a good reason for the matter to be heard in private. So one of the interesting points about this as well was that there was no notification to the press for the court for deciding to proceed in this way. The view of both Mr. Justice Raja and Mr. Justice Mostyn in a case EM from a few years ago is that no notice to the press is required for private hearings. No order is being made, and the cop is simply defaulting to sitting in private in accordance with Court Protection Rule 4.1, absent an order to hold an attendant hearing in public. This is a bit of a tricky thing to say because Practice Direction 4C does make clear that that is the normal rule, and that would obviously have to be taken very seriously in any decision being made to apply Court Protection Rule 4.1 rather than Practice Direction 4C. Practice Direction 4A governs the notification to the press for reporting restrictions, but again, there wasn't a reporting restriction in this case, so in the view of Mr. Justice Raja, this simply did not apply. Now, in considering some of the reasons why property and affairs may be a special case for transparency, we look back, as did Mr. Justice Raj in this case, to an older case, Independent News Media and A. And one of the things that was noted in that case was the particular position that people are in when they have lost capacity and need to make applications to the Court of Protection in order to help them manage their affairs. The Court of Protection did have various predecessor courts which fulfilled really similar roles. And what the court noted in this case was that the result is that the affairs of those who are incapacitated for the purposes of the Mental Capacity Act are examined before a judge in court. But that's not the way that most people would actually conduct their private affairs. The affairs of those who are not incapacitated would be handled and decided privately, at home, sometimes with, but usually without confidential professional advice. And none of these decisions is the business of anyone other than the individual or individuals who are making them. I'd also note this isn't set out in the judgment, but this would also similarly be the position of someone who had made a lasting power of attorney during their lifetime and had decided the person that they wanted to manage their affairs before they lost capacity. Those matters would not be determined by a court or be in front of a judge at all or be within the public domain. Now, obviously, there is a difference when a judge is making a decision rather than an attorney making a decision. That remains much more of a private affair, whereas a judge making a decision is inherently a public affair because it is a judge making the decision. But the view of the court in Independent News Media and A was that the new statutory structure of the Mental Capacity Act starts with the assumption that just as the conduct of their lives by adults with necessary mental capacity is their own affair, so too the conduct of the affairs of those adults who are incapacitated is private business. Hearings before the Court of Protection should therefore be held in private unless there is good reason why they should not. And I would note this preceded Practice Direction 4C and this preceded the transparency pilot, which started in 2016. So this is older case law. But it is really interesting in terms of looking at the historical background of this and the view of the court at that point in time, that the Mental Capacity Act and the Court of Protection rules were essentially continuing a long-term trend of giving privacy to people who were before the Court of Protection. Now, another view is set out in the case of Hinduja and Hinduja. This was a really interesting case which did attract quite a bit of media. And interestingly as well, it was a mixed property and affairs and health and welfare case. There were decisions and a number of reported judgments around transparency in this case, which involved applications relating to lasting powers of attorney, property and affairs, and the health and welfare of Sri Chand Hinduja. This was also a case that was running alongside in both the Court of Protection and in the Chancery Division, and there was a view that was expressed by the judge hearing the case in the Court of Protection that the Chancery Division proceedings were affecting what was happening in the Court of Protection proceedings. There was also a very real concern raised by the judge that he felt that Mr. Hinduja's welfare was getting lost within all of the court proceedings, and he made the decision, somewhat unusually, to name Shrikant Hinduja. So not only to have the proceedings taking place in public and subject to reporting restrictions, but actually naming the individuals about whom they related. Now, one of the reasons that this was also set out was because it was agreed there was essentially no way to meaningfully report about the Hinduja family without a very significant risk of jigsaw identification. By saying almost anything about their business interests, it would be very clear which family was being discussed and potentially which member of the family was being discussed. But there was still a reporting restriction made, which covered things like the exact clinical diagnosis that he had, the daily care that he received, and what sort of time he spent with his wife, to create some sphere of privacy even within these proceedings. But the court also noted that somewhat unusually, it was his litigation friend, the official solicitor, that was suggesting to the court that these proceedings should name Mr. Hinduja, partially due to a concern that his welfare was getting lost and a hope that the publicity would have a salutary effect on him. The Court of Appeal did set out in its ruling on the case that these proceedings were highly unrepresentative of the bulk of the work of the Court of Protection, and they felt that Mr. Hinduja's case is very much a case on its own fact and had few, if any, implications for other cases. However, it perhaps has a bit more implications for the case of W&P, which seems to be another very high net worth individual in the public eye, with the court taking a very different decision to sit entirely in private. However, in that case, there is nothing obvious on the face of the case that suggests that there were any concern whatsoever for P's welfare or that there was any public dispute within the family. So in summary, in looking at privacy and property and affairs, most applications are considered without an attended hearing to which there is no public access. When there is a public hearing, most of the preliminary phases do again proceed in private and are not subject to the normal presumption of making an order public. The first likely attended property and affairs hearing is the final hearing, and if no order is made under Practice Direction 4C, as in the case of W&P, they would remain in private throughout.
Thank you very much, Ariana. Before I hand over to Katie, I should point out that if you've got any questions, do put them in the Q&A box at the bottom of the screen. I think someone's already put one question. Right, now I'm going to hand over to Katie. Over to you.
Thank you very much. Right, I hope you can see my screen. I'm a novice, I'm ashamed to say, at screen sharing, so you'll have to bear with me. I'm going to talk to you about privacy in health and welfare applications, and I'm really grateful to Ariana for setting out the nuts and bolts of the rules, so I'm not going to repeat that. But you know, we know that in health and welfare applications, despite what the Court of Protection rules say, which is that hearings should be in private, actually the practice directions say the starting position really is that they are going to be in public. So I'm going to talk to you about three different kinds of information that the court is commonly asked to consider restraining from publication. So first of all, information that leads to the identity of P in health and welfare hearings. Secondly, information that might go to protect the integrity of the proceedings. And thirdly, information in respect of other information in respect of health and welfare proceedings. And really, I'm going to concentrate there on protecting the identity of third parties, so not P. So first of all, dealing with P. So as I say, the court sits in public with a transparency order in place, unless there's good reason not to sit in public. And that is really quite rare in my experience, that the court sits in private. And the kinds of good reasons that I've come across in cases that I've done where the court said, well, there's a good reason why we're going to sit in private, is where even with a transparency order, it would become obvious who the P was. And it seems to me that is, or it may have been, the circumstance that Mr. Justice Raja was met with in W&P. And so I just posed the question, and others may have a view about this, as to whether, and it's difficult to know because we don't know much about the case, but whether if the W&P case had come before the court for health and welfare decisions, the court may have come to the same view that actually they couldn't sit in public because it would inevitably lead to the identification of P. I'll just put that out there. And I've certainly had a case where the court took the view that if they sat in public, P would be at risk from third parties, and that was a reason to sit in private. I'll just talk about the nuts and bolts of how this is achieved, because I think it's important and goes to what some of the case law says and some of the problems that people have identified with the practice in the court of protection. So my practice is, when I'm when I'm getting involved in a case at issue, is to provide a draft transparency order for the court. But the practice direction is clear that an application is not required for a transparency order to be made. So, and my experience, again, of what the court does in most cases, if not all cases, is that when they are listing the first attended hearing, they will also issue a transparency order, either in the form of a draft that's been provided by the applicant, or in a standard form. And of course, if that hasn't been done when you turn up to your first hearing, then you have to make sure that before you start opening any case in public, that there is a transparency order in place, and you must make sure that any observer that is attending has seen that transparency order and understands its terms, because it is an injunction, and if you breach it, you are in contempt of court. So those steps are all really important. But what I want you to really notice is that the court issues a transparency order without an application, without any evidence to support it, and without any submissions being made by any particular party as to its terms. So going on then to my first category that I outlined at the beginning, the information that is going to be prohibited from publication that goes to leads to the identification of P. Now, this is the most uncontentious of the information that's restrained from publication. And the standard transparency order is in those terms. It prohibits anything that identifies P, and as Ariana has said, that can go wider than just naming P. It could include anything that leads via jigsaw identification to P being identified. And it can cover those that care for P, and it can in some circumstances really be quite wide. Now, there are obviously exceptions to those, and we've all come across cases where P has been named. So that can happen broadly, I've said, in two categories, but I'm sure that those that are listening might think of many more. So where there is already information about P in the public domain, and so effectively you're trying to shut the door after the horse has bolted, there are those category of cases. And then there are some cases where P wants to be named, and a recent case of that nature is the Took case, where I think P was wanting to go on a transplant list, and the family thought that if he was named and there was some publicity about the case, oh, I'm sorry, I've gone too far, then it might increase the chances of a donor being found. So it's important to note that the general principles apply in the Court of Protection about open justice in the same way that they apply in any other court, whether that's the King's Bench Division, the Chancery Division, or the family courts. So the starting point is open justice, and what we're looking at is the circumstances in which there can be a derogation from open justice. And the circumstances in which the court might derogate from the principle of open justice is in order to protect the article rights of somebody. And obviously in court of protection proceedings, the first person we think about is P. And so what the court does is it balances the Article 8 rights of the person P with the Article 10 rights at play and the principle of open justice. but the starting position is open justice. And when the balance is carried out between Article 8 and Article 10, neither of those rights has precedent over the other, but they've got to be, the case law says they've got to be balanced against each other. But as I have pointed out, the procedure in the Court of Protection for Health and Welfare cases is that transparency orders are made automatically by the court without application, without evidence, without submissions. And the critics of that process point to the fact that that is inconsistent with the case law. So one of the leading cases, which is often cited in this area, is the case of Re S from 2005. And that tells us that where Article 8 and Article 10 are in conflict, the court needs to bring, and this is a quote from the case law, an intense focus on the comparative importance of the specific rights claimed in the individual case. And that means evidence must be brought to the court, and the court must be told why the particular person's Article 8 rights is going to be interfered with and in what way. And that is, of course, not what happens in the Court of Protection in the procedure that I've just outlined. And the case of Miss Justice Mostyn in the case of Re EM was concerned about this and raised his criticism of the procedure, saying, first of all, that that procedure, making orders without evidence and submissions, and carrying out the balancing exercise in each individual case on the facts of that individual case, was not consistent with Re S. And he was also concerned about the fact that the press were not being notified each time a transparency order was being made. There are the best justification that I've come across for the procedure is that set out by our very clever colleague Alex Ruck-Keene in his blog, Mental Capacity Law and Policy. And what he has said there is that it could be said that the making of the order represents the implicit summary judicial determination that the appropriate Re S balance, that balance between Articles 8 and Article 10, is as set out in the practice direction, and that the summary determination is appropriate where Parliament has decreed that the starting point is that the tap of publicity is off. That's through the practice direction, that's through the COP rules that Parliament has approved, and the court is deciding whether to turn it on. So that's the best analysis that I've seen as to how you square what the practice in the Court of Protection is with what the case law says ought to happen. So moving on then to the second category that I want to talk about, and that is where information is prohibited from being published because it if the information, in order to protect the integrity of the proceedings. Now, this comes in large part from the Court of Appeal case of Abbasi, but we need to be a little bit careful about this because Abbasi, well, the appeal to the Supreme Court in Abbasi took place more than a year ago. And so we are waiting, we hope, imminently for a judgment in the Supreme Court. So we don't know what they're going to say. But as things stand at the moment, Abbasi is clear that it is appropriate in some circumstances to restrain the publication of information in order to protect the integrity of the proceedings. Now, this arose in Abbasi and commonly in serious medical treatment cases concerning the withdrawal of life-sustaining treatment, usually ventilation, from children and babies because of the heat that is generated in those cases. So what was said in Abbasi at paragraph 121 is that experience has shown that end-of-life proceedings generate a firestorm on social media sometimes fanned and taken advantage of by organisations and individuals with strongly held beliefs about the morality of withdrawal of treatment. The firestorm often overwhelms calm debate. Reporting restriction orders become essential to protect the integrity of the proceedings and those caught up directly and indirectly in them. And many will remember the very difficult circumstances around some of the earlier cases in Alfie Evans and so on, where there were marches and people blockading staff from getting into hospitals. And it's to guard against that kind of risk that sometimes applications are made to the court to say, look, while the proceedings are ongoing, which are extremely difficult, while clinicians are having to care for this child, we don't want them being distracted by publicity, by being slammed on social media, by being trolled, etc. And so in order to protect the integrity of the proceedings, during the currency of the proceedings, court, we want you to not name those people that are involved in it. And that's a particular category that the court will protect. But as I say, it's only during the currency of the proceedings. So then we come on to the much more controversial category, and that's restricting the publication of other information. And really the largest category, the most common way in which this comes before the court is in relation to people saying, well, hang on a minute, if you name me in a judgment that's going to be, I'm not P, but if you name me in a judgment that's going to be disseminated into the public domain, you're going to interfere with my Article 8 rights. And so when I want you, court, to carry out the balancing exercise in relation to my Article 8 rights. And it's important to note that if a court does make an order of this nature, then that is an order that can continue beyond the life of the proceedings. So that's what the case in Abbasi was concerned about to some extent, because what Abbasi and Hastrup, what had happened was that the court had made orders, indefinite orders, orders for a long period of time, restraining the identification of certain members of the clinical staff. And by the time it had got to the court some years after the deaths of these children, the families wanted to be able to tell their story, and they felt very strongly that they wanted to be able to name the clinicians who had been involved. What the Court of Appeal held, that when the court is being asked to curtail the freedom of speech of these families in order to safeguard Article 8 rights, what is required is an intense fact-sensitive evaluation and balancing exercise. So we can immediately see there that the court is drawing on the cases such as Ries. And they went on to say the practical realities of the balance in such cases will be that evidence of a compelling nature is needed to curtail the legitimate exercise of free speech. So you can, again, immediately see that in this category of cases that are coming before the court is taking a very different view to issuing the standard transparency order at the outset, where the court is trying to protect the identity of P. So in this third category of applications, evidence is required, submissions are required. And the court made the point that the applications are particularly difficult to make out when there is only a risk of behaviour that may result in a lack of respect for the private life of the individual. And the court approved the judgment of Mr. Peter Jackson, as he was then, in the Re-F, a child, setting out what needs to be covered off by the evidence if you're talking about a risk of a breach of your Article 8 rights. And again, the similar wording, there must be an intense focus on the type of risk that is involved, how likely it is to happen, and what the likely consequences might then be. Only by carrying out this exercise is it possible to know what weight to give to the risks before setting them alongside the other relevant factors. So it's really quite granular evidence that's required to be put before the court. One can't just sort of turn up and say, oh, well, we're a bit worried that we're going to be trolled on social media if you name our clinicians, for example. You've got to go further than that. And Abassi is interesting as well to note that it's not sufficient to say to put the court can't weigh in the balance any concern that professionals might be criticised if they're named, or that there may be systemic issues in terms of recruiting particular professionals if they're named in judgments. Those systemic issues for the NHS, which was put before the court, are not relevant to the balancing exercise that the court needs to undertake between Articles 8 and 10. So my last slide is to just make the point that this really is a hot topic. I've got a weird N there in my title. There are judgments coming out at a high level in the courts all the time on this case. A recent example of that is the Court of Appeal case of Tickle. Some of you may have read that. That was a case in which the Court of Appeal allowed an appeal against a decision of Mr. Justice Williams in the Family Division that 3 judges should not be named. And these 3 judges had made orders in historic care proceedings. And the appeal was allowed on a number of different bases, but including the fact that the judge had no evidence about the Article 8 risks to these judges, had heard no submissions in relation to it, and so an application hadn't even been before the court, and the Court of Appeal was clear that that would be required before making an order of that nature. As I've already said, we are awaiting the decision from the Supreme Court in Abassi, and it may be that changes the landscape, or it may be it doesn't. We just don't know. But sitting behind that, I know of at least one important case, and there may be others in different areas that are waiting for the Supreme Court to hand down their judgment in Abassi. So some of you may be aware of Mr. Justice Nicklin's decision in PMC in a local health board, in which he determined that a child claimant who was bringing proceedings through a litigation friend in a clinical negligence claim could not be granted anonymity in an application brought shortly before the first attended hearing for a quantum-only trial. And again, he looked very closely at what evidence had been put before the court to say that this child's Article 8 rights would be breached by being named. And it was said rather generally that if this child, because they were a minor, because they had disabilities, was named in a judgment which also made it clear that they had received a large award of damages, they would be at risk. So quite general evidence in relation to that, and the court was not satisfied that that was sufficient to displace the open justice principle. And that has caused some significant stir in personal injury and clinical negligence practice. And it also brings into that case is interesting as well, because it brings into view what is published by legal publishers. So Westlaw collects information about cases that have been published and publishes them on what's called Westlaw dockets, for example. And so if you issue issue proceedings, you can then search on those proceedings and see what orders have been made and so on. And so if people aren't seeking anonymity right from the outset, there is already information in the public domain about their case out there, even if there hasn't been an attended hearing. And so that brings in to play a whole nother aspect that the court needs to consider. So I'm going to stop sharing my screen now and hand over to Joshua.
Over to you, Joshua.
Thank you very much indeed. Well, I learned a great deal by listening to those two talks and found it absolutely fascinating. Shall I start with the Bassi, because that's where we ended, just to briefly remind people, or perhaps even tell people who are not familiar with this. Mr. and Mrs. Abbasi were the parents of 6-year-old Zainab, who died in 2019. The other family are the parents of a child called Isaiah, who died in 2018. They were both being cared for, and reporting orders protect the identities of the clinicians who were looking after them. I haven't got the precise details here, but this was all about withdrawing treatment because their lives were, the court decided it was appropriate to withdraw the treatment in the best interest of their children, as I recall. And the point here, of course, is that the identity of the child is well known. We know what the children were called. The identity of the parents is known. The question is the identity of the clinicians who were looking after them. And what the parents are saying, and why they've appealed to the Supreme Court, is that they can't meaningfully discuss or write publicly about the circumstances in which their respective children were treated and died. And the mainstream media can't do so, assuming that the parents are able to spark interest in the circumstances of these cases. And I'm not completely sure whether that's right as a matter of how journalism works. It ought to be possible for these bereaved parents to talk about the treatment that their respective children had without naming the doctors, just as, it's possible to talk about the murders of which Lucy Letby was convicted without naming the children who died or their parents. So I'm not sure that naming the clinicians would really enable a great deal of information. On the other hand, as a matter of principle, journalists will say, well, we always need to name the clinicians. It's important that the right people are identified. It's important that we don't identify the wrong people. It's important that others are not improperly caught up in a case because they're assumed to be part of the clinicians who are treating these children and were not. So I'm not completely sure that it's necessary to name them. On the other hand, I'm not completely sure that it's necessary to give them anonymity, because I don't think that the risks to them all these years later are as great as is being contended on their behalf. So I think it is a really difficult question for the Supreme Court, and I look forward to seeing what they had to say. The case I was expecting to say a little bit more about is the one that Arianna was talking about at the beginning. The case of the multimillionaire with severe dementia. I say multimillionaire because his assets are worth approximately £20 million, and not necessarily in cash. They may be property, maybe art, I've no idea, we're not told. And his wife wanted the High Court to make effectively tax-saving arrangements for distributing his assets. And Mr. Justice Raja, who's a Chancery judge sitting in the Court of Protection, said that giving advance notice of the hearing to the press would have undermined the purpose of the proceedings. We know that P has severe dementia. He lacks meaningful cognitive capacity. He's unable to comprehend, retain, or use information presented in any form relevant to a decision to make a gift or manage his affairs. He can't communicate. His life expectancy is limited. Crucially, his condition is not generally known to others outside his immediate family. Nothing surprising about that, but P is a figure who used to be in the public eye and in whose affairs there is likely to be natural public curiosity. So he wants to make a statutory will. He wants the courts to enable his family to save tax, and he wants to do all that in private, and we're not to be told anything about it. And the crucial line in Mr. Justice Raja's judgment is that identifying P could have serious consequences for P and his family. Now, I don't know what that means, and there's nothing in the judgment to explain. So, of course, you speculate. Obviously, it's not going to affect him because he has severe dementia. He doesn't know anything about it. It can't embarrass his family that he has dementia. It's not embarrassing. I mean, it's tragic, but it's not embarrassing. So what consequences could it have? somebody might break into his house and steal his paintings. Well, you have locks on the doors. I can't understand what the serious consequences for P and his family would be without further explanation. I fully accept that it would not be possible to craft reporting restrictions because of the risks of jigsaw identification. But I'm not persuaded that the judge was right to give no notice to the press of the hearing earlier this month and to decide that there would be no published judgment on the substantive issue. Professor Celia Kitzinger, who's watching this discussion and who runs the very well-respected Open Justice Court of Protection project and who alerted me to this ruling, she wondered why Mr. Justice Raja didn't follow the procedure adopted in the Hinduja case that you've heard about. She says that when journalists eventually applied for restrictions to be lifted so that the Hinduja family could be named, there were multiple careful hearings about what details couldn't be reported, and she thought that was the way it should be done with people who are in the public domain. And she says the case is concerned with statutory wills, which are clearly a matter of legitimate public interest. Many people don't know that you can write a new will or change an existing one in the best interest of somebody who lacks a mental capacity to do it for themselves. I know that to be the fact because when I covered this on my Substack blog, a friend of mine who does work at a CAB said, I didn't know that a person could make a will without the capacity to do so, and it's not widely known. So it is important, and this is what Celia Kitzinger says, it is important for the public to know that it's possible and to understand how the court resolves disagreements. And there are very few published judgments on statutory wills. And she says she's concerned the court was not able to benefit from submissions by journalists and members of the public who have hands-on experience of balancing privacy rights with freedom of information. She says it may well be, and she's right. The judge would have reached the same decision and kept the case private, but he would have had the opportunity to explore the transparency issues more fully, and we, the public, could be more confident that he'd got the right answer. It's wrong, she says, and I agree, that we had no opportunity to persuade the judge that we ought to have permission to observe the hearing without reporting it, as we journalists and people like her have done many times before. She says that's secret justice, and I think that must be right. How can the courts, I say in my blog, how can the courts properly balance competing interests unless they've heard the arguments from both sides? That's probably all I've got time to say.
All right, Joshua, thank you very much. So I don't think at the moment we have any questions from the audience, but I have one which I think occurred to me during Joshua's very interesting talk. So what if there are cases out there in which it is so sensitive, either for financial reasons or they could be social reasons relating to P, where even disclosing to the media the identity of P and the issues in the case would run an unacceptable risk of severe consequences for P? Can you conceive of a category where it is too risky even to disclose to the media who P is and what the issues in the case are?
I can certainly see circumstances where you might not disclose the name of P. But there are often cases, and you see these reported, where there is a request for very severe reporting restrictions, sometimes on grounds of national security, all sorts of other grounds, and the court decides that it can actually hear most of the case in public, maybe on assumed facts in national security cases, maybe in anonymity. The question really is whether you can trust any journalists at all. And the experience of cases is that so long as you don't make it a complete free-for-all, yes, you can trust certain identified journalists with a reputation worth losing. It's worth observing that in the Court of Protection, as far as I understand it, when it's open in many cases to just members of the public, whereas the family division is open only to accredited journalists and accredited legal bloggers. So, you've got a court which is ostensibly open to the public as a whole, and therefore it's much more difficult to ensure that a court order is obeyed because, people give false names and addresses. How can you enforce it if somebody leaks it? But if you've got a very limited number of people in court who are named journalists and who are known and who can be trusted to some extent, if that's not a contradiction in terms, then I think it is a matter of principle right that we should be allowed in, at least to make representations, at least to answer questions from the court, at least to be seen to be arguing for open justice.
So you support the idea that there can be disclosure to certain journalists, just not in general. It shouldn't be notification to the media in general. And that's the way the media's perspective can be taken into account before making a ruling on whether a hearing should be in private, for instance.
Yes, I do. I mean, you could even have counsel for, journalists. So the journalists themselves don't come in, all right? Have
They'd
difficulties.
have to take instructions, though, wouldn't they?
Well, they would, yes, and you then get into the sort of role of special advocates who, and all that sort of thing. It would be possible to do something other than to simply say, I've decided this, I wasn't going to tell you about it, I'm telling you about it now, that's it, end of story.
Right, Katie.
Can I come in on that? I think we have to as well, don't we? We have to look to our experience in relation to this. So we've got many years of making applications for injunctions for reporting restriction orders by service to Copy Direct, who then circulate it out to all of the national media organisations. And as a party who is making such an application, you have to take a deep breath, because what you are doing is disclosing to the media that you want to get reporting restrictions. You have to explain to them what the case is about. You have to give them some information, and there is no reporting restriction order in place. So there is nothing for the media to breach. But I am not aware of a case in which the media have, those reputable members of the media have, before the reporting restriction order has been made, published something. What they do is they act responsibly. They see that this is an issue, and although there is not a reporting restriction order in place, if they want to argue against it, they'll come to the court and do it. They won't just publish before it's made. So I think we need to look to the history and say, well, actually, I think, Joshua, what you say is right. There are reputable journalists who can be trusted.
And don't forget, the Supreme Court, generally speaking, not in all cases, there are exceptions, provides copies of its judgments under embargo. There are circumstances when there are lots of foreign journalists around and they don't trust people, or if there's financially sensitive information, or if there's a real risk of it being leaked. But we are given judgments under embargo, as of course a counsel, in different circumstances to check for typos and so on. And there are all sorts of circumstances. I mean, journalists are given confidential information. Some of them will obviously leak it. Some of them will let it be known. But thank you very much for the support for journalists. And, we do have a significant role. We're often approached in court by the judge, asked to stand up in the press bench and make representations. And we do. Yes.
So just on that point, Joshua, you'll be aware, I think, of the judgment in the will of Prince Philip, where the application took place in private, and that was expressly challenged both at first instance and in the Court of Appeal. And you'll recall the Court of Appeal said that this was one of those cases where open justice didn't permit or require the media to even make representations.
Okay, but even in that case, and just looking at it slightly more broadly, that arose because Sir Andrew Macfarlane decided to at least read out the labels on the documents in his safe. We now know, because he told us, whose royal wills have been sealed. We don't know what's in them, but we are at least aware of that. And obviously we know that Prince Philip's will is still sealed. The point I'm making there is that it's possible for some information to be published without all information being published.
Yes, well, I see that. But I think that if there are cases in which there it may be lawful to not even give notice to the media to seek representations. We can't tell from this judgment whether this case was properly one of those. And you can kind of see the possibly irritating logic that this is one of those cases, and I can't tell you why. Because if he did tell us why, that would probably tell us more than we ought to know, I suspect.
Yeah, I don't particularly like, I know Mr. Justice Raja can't reply to this, and that's understood, but I'm not particularly impressed with him saying the public may be curious about the private affairs and the wills of those in the public eye. It does not follow that there is a legitimate public interest in those matters. And then he cites the Prince Philip case. After all, wills are published once they're proved.
Yes, that's true, but I think the basic rationale. So I entirely understand your concern, and Professor Kitzinger's as well, and I to some extent share it. But my point is that if there are cases where it is right that they are so confidential, so potentially damaging to P, that the hearing must take place in private, and there's no submissions on that because it's so clear what the merits are, then we can't say whether this case is properly one of those cases, because possibly understandably the judge hasn't explained exactly why.
I accept that.
But there we are. So I can see what the concern is. And I have also seen I don't think it's a question, it's an assertion by one of the attendees that the Open Justice Project has observed dozens of private hearings, including closed hearings. There have been no breaches of those injunctions by members of the public. We can be trusted too. So I'm sure that's true as well. But I think this is an interesting question as to what the limits of this principle are, and if there are journalists who, in particular, who have a track record of being trusted, the argument that they can't be trusted in certain cases might be harder to maintain, I think. So,
I'd like to support that.
Well, no, well, I fully understand that. Right, okay, well, we promised you an hour, and we've given you an hour and 4 minutes, and there are no further questions, I think, appearing on the Q&A, so I think it's time for us to bid you all good evening. Thank you very much, everyone, for attending, and we'll see you on another occasion. Good evening.